Hey everyone, and welcome. Today we're diving deep into a concept that's absolutely crucial for any student of the law: arrest. I mean, who actually has the power to arrest? When can they legally use it? And what are the exact rules they have to play by? Well, let's break it all down. So let's start with the most basic question. What really is an arrest? You have to think of it as a balancing act. On one side, you've got Article 21 of the Constitution, your fundamental right to life and personal liberty. And on the other side, you have the state's duty to keep law and order. Arrest is that powerful legal tool that operates right in the middle of that tension. So here's how we're going to tackle this to make it super clear. First, we'll nail down the real meaning and purpose of an arrest. Then we'll get into the police's power under the new Section 35 of the BNSS. That's what's replaced the old CRPC. We'll spend some extra time on the rules for less serious crimes. And then we'll get to the really interesting stuff: the arrest powers of private citizens and even magistrates. All right, first things first. We've got to build a solid foundation here. Because honestly, if you don't get the core meaning of arrest, everything else that follows is just going to be confusing. The word arrest actually comes from the French word arrêter, which just means to stop. But, and this is a big but, in legal terms, it's way more than just being stopped on the street. It is the complete deprivation of your liberty done by someone with legal authority. It's so important to remember that not every time your movement is restricted is it an arrest. It has to be that total restraint. And here's something that might surprise you. The word arrest isn't actually defined in our main criminal laws, not in the old ones and not in the new ones like the BNSS. The Supreme Court even pointed this out. So what does that mean for us? It means the definition is always being shaped by court decisions, which makes understanding how it works in the real world even more critical. Okay, now let's get to the people we all think of when we hear the word arrest: the police. We're going to zero in on their power to arrest without a warrant, which is all laid out in a super important Section 35 of the Bharatiya Nagarik Suraksha Sanhita, or BNSS. Now, this is where things get really interesting, because police powers are split based on how serious the crime is. For the most serious stuff, crimes punishable by more than 7 years or even death, an officer can arrest someone based on just credible info or a reasonable belief. Simple enough? But for less serious offenses, the bar is set much, much higher. The officer can't just arrest. They have to prove it's necessary based on a specific list, and they have to write down their reasons. That extra step is a huge safeguard for our personal liberty. This necessity test is such a big deal, so let's get into the nitty-gritty. What exactly does an officer have to justify before they can arrest someone for one of these less severe crimes? Just think of it like a checklist the officer has to run through in their head. They have to be able to answer yes to at least one of these. Is this arrest the only way to stop them from committing another crime? Is it absolutely essential for a proper investigation? Is there a risk they might destroy evidence or scare a witness? Or is it the only way to make sure they'll actually show up to court? The bottom line is, arrest isn't automatic here. It has to be justified. Now, of course, Section 35 also gives police some other, let's say, more straightforward grounds for a warrantless arrest. We're talking about things like dealing with the proclaimed offender, catching someone red-handed with stolen property, or someone physically stopping an officer from doing their job. In these situations, the act itself is the justification. So we've been talking a lot about the police, right? But here's a question for you. Are they the only ones who can make an arrest? The answer might actually surprise you, and it leads us to some really fascinating parts of our criminal law. You heard that right. Even a regular person, a private citizen like you or me, can make an arrest. This power is laid out in Section 40 of the BNSS. But, and this is key, it comes with some very strict rules. The whole procedure is a clear 3-step process. 1, you have to personally see someone commit a serious, non-bailable offense. We're talking robbery, murder, or see a known proclaimed offender. 2, you can then arrest that person. But 3 is the most critical part. You have to hand them over to the police immediately, and definitely within 6 hours. Your power stops there. Your job is just to detain and deliver. That's it. Okay, so we've covered police and private citizens. Let's move on to our third and final category, the magistrate. Under Section 41 of the BNSS, a magistrate can also make an arrest, but again, only in very specific situations. So there are basically 2 scenarios here. First, if a crime is committed right in front of a magistrate, and they are within their own local jurisdiction. They can make the arrest right then and there. The second scenario is they can arrest anyone who is within their jurisdiction if they would have had the power to issue an arrest warrant for them anyway. The common thread, the key phrase here is local jurisdiction. So what does local jurisdiction mean in the real world? Let's paint a picture. Imagine a magistrate from Punjab is on vacation in Goa. If they see a crime happen, their official power as a magistrate does not travel with them. They can still make an arrest, sure, but they have to use the power of a private citizen under Section 40, not their special magistrate power under Section 41. It's a perfect example of how that power is tied to a specific geographical area. This leads to a really crucial point about fairness that comes from case law. If a magistrate orders an arrest, they cannot then be the judge who decides on that person's custody or remand. The person has to be taken to a different magistrate. This is a vital check and balance in our system to avoid any bias and to keep powers separated. All right, let's do a quick recap on who can arrest without a warrant. First, you have the police under Section 35, with the widest powers but with big checks and balances for smaller crimes. Second, you've got private citizens under Section 40 with a very narrow power, basically acting as a first responder. And third, you have magistrates under Section 41 whose power is strictly tied to their local area. 3 different players, each with their own set of rules. Okay, so we've covered a ton of ground, who can arrest and when they can do it, but that's really only one side of the coin. The next huge question that every single citizen and law student needs to ask is this. After someone is arrested, what happens then? What rights do they have? Well, that's a story for our next explainer. Thanks for joining me.